Justices of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business before the court, draw near with their attendance, and they shall be heard.
Thank you. Please be seated. We've got 2 courtrooms operated today, which is a little bit unusual. 2 barbers, no waiting. So the first case on for argument today is case 47, People versus Williams. Counsel, can you hear us?
I can hear you. Can you hear me, Your Honor?
We can, very well, thank you. Proceed.
Good morning. May it please the court. I'd like to first address point 2 of our brief, in which we urge that the court below violated its obligations and responsibilities to inquire into credible complaints regarding counsel and to exercise its discretion regarding the request for substitution of counsel. After numerous oral requests for change of counsel, the court below requested Mr. Williams to place in writing the basis of his request, and he did so. He stated 2 separate reasons. One, the failures to comply with his request to testify at the grand jury, but then a second reason, which is that he stated that he had made numerous phone calls to his attorney and received no response either by visit, orally, or by letter. The court below conducted no inquiry of the attorney as to whether that's correct, no inquiry of Mr. Williams as to what it was he would want to speak to his attorney about, and all the court did was simply say, well, I know this attorney, he's generally a good attorney, so I'm denying the request. There's not a lot that's required in terms of the inquiry, but it has to be some inquiry, and respectfully, it's not enough to ask the defendant to state his grounds. There has to be a response to that. If we don't know if in fact there were serious issues that Mr. Williams wanted his attorney to address, and we don't know that because the court below failed to make the requisite inquiry. The case the closest to this cited in our brief is People versus Jenseki, and we'll rely otherwise on that point in our brief. In point 3 of our brief, we urge that the sentence imposed was harsh and excessive, where the prosecutor, aware of both Mr. Williams' criminal history and aware of the factual allegation in the case, having secured the indictment.
Counsel, in this particular case, we've got a plea, and you correct me if I'm wrong, because you know the record better than I, but you got a plea offer of 5 years with 5 years PRS, and that was based upon the charges that were pending at the time. In this case, your argument, I think, is that he was convicted of a lesser charge, yet he's got a sentence of 8 years with 4 years PRS. Is that right?
That's correct. He was acquitted of the 3 top counts. He was acquitted of burglary in the 1st degree, acquitted of assault in the 2nd degree, and of aggravated criminal contempt. He was only convicted of 2 lower counts. So it's our position that given this disparity between what was offered in the plea when he was facing more charges, more serious charges, and given the fact there were no new facts that came out, this court should do here what is done in numerous other cases, noting the disparity between the plea offer and the sentence imposed. And I would just finally note in that regard, last week in People versus Brisbane, the Court of Appeals, citing 2 decisions of this court with approval that had reduced sentences because of such a disparity. That noted that this court has the authority to consider that disparity in determining whether or not a sentence imposed was harsh and excessive and should be reduced. We urge that in the cases cited by the Court of Appeals in Brisbane and the other cases cited.
We'll take a look at that, counsel.
Thank you.
Thank you. Counsel?
May it please the court, good morning. In order to save time, if there's anything in particular that you'd like me to address, I'll address the items brought up by Mr. Schiffrin.
No questions.
So as to the request for substitution of counsel, it must be a seemingly serious request. This defendant had had numerous conversations with the previous judge and then Judge Williams, who was the presiding judge after that. The main complaint the defendant had was not being able to testify in the grand jury, which, as you're aware, is ultimately for the defense attorney to decide. and that he had been
And
trying
one could
to.
argue that that was a pretty solid decision, if there was such a decision, not to have the defendant testify, who at the time, if I understand the record correctly, was either already convicted of a crime against the same victim or was under prosecution for that crime, I think an assault.
He was currently charged, committed this crime while out on bail on that case in Monroe County.
And counsel, isn't it also the case that the evidence in the record seems to indicate that clearly the district attorney sent the appropriate letter,
Correct,
right, to the
Correct.
defendant, and I think copied counsel.
correct.
And at this point, there's nothing in the record that where counsel saying, I did not receive that letter.
Correct.
Counsel said, I can't find it in my file, which is a much different thing.
Correct. He said, I cannot say right now. In fact, at one point said, I'm aware that notice was originally sent out. So I don't know if he was talking about when it was eventually presented to grand jury. It was also sent to defendant. Defendant never stated.
That's a little more
It's a little
questionable because
questionable,
defendant was, I mean, if our decision was resting solely on, did the defendant get proper notice of this? You know, I may be in a completely different mindset about how we analyze this, right?
Right.
But because he was being held and then he was being transferred to another facility. And
Correct.
so, and there's nothing in the record I see which indicates the defendant actually got received the letter.
That's correct.
Yeah,
I definitely could not say
But
that.
clearly the attorney did receive notice and that's sufficient. I believe is what the case law is telling us.
Yes, Your Honor.
Okay. Anything further?
Just regard to sentence, with regard to the point that Your Honor brought up, the offer was made originally, as stated in the record, to 5 years plus 3 years post-release supervision. By operation of law, had to be consecutive because he was out on bail on the other case. The sentence imposed of 8 years is not so disparate as to raise per se inferences of that he was punished for testifying. And if looking at the record
I
as a
mean,
whole.
counsel's correct. We do have cases where we do reduce the sentence in appropriate circumstances, but we look at a lot of factors when we make those determinations. Not simply was there an offer before that is different than the offer after.
Absolutely. And I would ask you to look at the PSI in that regard.
Thank you, counsel.
Anything else? Thank you.
Case 48, People versus Burroughs. Counsel, proceed.
Morning, may it please the court. Tanya Plank for Marquine Burroughs. The court erred here in denying Mr. Burroughs' CPL 3030 motion, and the charges against him should be dismissed. As this court well knows, for a proper COC, the people have the burden of showing that they exercise due diligence and made all reasonable
Counselor?
inquiries. Yes.
We have a relatively new decision out called Chase Walker, People versus Chase Walker. I'm not sure you're familiar with that one, but there the memorandum that we issued identified what we referred to as the relevancy prong of the initial disclosure obligation and the possessory prong.
Right.
So here, would you agree that at least with respect to the law enforcement disciplinary records, they would not satisfy the possessory prong? Because at the time that the COC was filed vis-a-vis the initial disclosure, they were not and could not be, as a matter of law, in the possession of the people. Do you agree with that?
Well, I agree with that. That at the time the people couldn't turn it over because of the civil rights law. That's what I understand you're asking. But then when that was repealed as of June 12th, 2020, at that point, they were required to turn it over. That's my argument on that, is that they were required to turn it over after the repeal, and it was in their possession because it was in the disciplinary record file, the portal.
But that was later on. That was not at the time that initial discovery was made. And an argument can be made, I think, that initial discovery under subdivision 1 or 245.20 is what is the basis of the 3030 motion. Otherwise, you're relegated to sanctions. But when you're talking about dismissal based on speedy trial, you're talking about initial disclosure, correct?
Correct, but the people do have a continuing obligation under
No
245.60. Yes.
But
So-
the law is not applied retroactively either.
Well, I would argue under Abbotoy v. Baxter it should be applied retroactively to the June 12th period.
So your position is that what, the day the law took effect, that every case in New York State, the DAs should have turned over this info, even if they already had a COC issue?
Yes, because and filed the supplemental COC at that point. Yes, that's my argument for the disciplinary records. And then there was also other information, items of discovery, such as the
pistol
four witnesses.
The pistol permit information was also not within the possession of the people at the time they filed their COC vis-a-vis the initial disclosure obligation, correct? Because it was sealed.
That's not completely clear. It was sealed, the court said, but the prosecutor did have the information because he turned it over immediately after the 3030 motion. So he had it. He had the information. It's not completely clear whether he had it at that time, but he did have the information. So again, he could have done a supplemental COC. And then the four witnesses at the scene, I would argue that that's arguably the most problematic because this is Brady material, and the prosecutor just believed that he said that he didn't turn it over because he wasn't going to call those witnesses. And so, but it's not just impeachment material, it's Brady material potentially. So he had the obligation to turn it over regardless of whether he was going to call them as witnesses or not. And then the court never decided that issue.
Counselor, is there any evidence in the record? I just don't recall it one way or the other. But is there any evidence in the record that with respect to the identification of those four witnesses, that information was in the possession of the people, again, getting back to the possessory prong,
right,
within the time frame required to file a COC for initial disclosure? That is within, I think it's the most it can be under the law is 35 days after the indictment or the arraignment indictment, whatever it is. Forgive me for not having the precision, but the initial disclosure has to be made within a certain time frame. Is there anything in this record that shows whether that information that you're talking about, the four witnesses, was in the possession of the people during that time frame?
I don't believe there's anything on the record that shows that particular time frame. I just know on the record when the 3030 was made, at that point, that the prosecutor said he had two other names and he didn't turn them over. And he said that he didn't turn them over because he wasn't calling them as witnesses. So I would argue it's inferable that he had that information and he just didn't turn it over because he believed he didn't have to and not because he didn't have it.
Okay.
Sorry, Counselor, just to be clear here, I think the contention is exclusively that there was a speedy trial violation here.
Yes.
There's no contention that there was a discovery violation, so that there might be some discovery sanctions.
No, I'm arguing that this was a 3030 violation
just
because of the
violation.
the time period had already lapsed. It was well beyond 6 months, even accounting for the executive decisions and everything. So if there are no other questions.
Thank you, Counsel.
Good morning, Amy Wallensack on behalf of the people. Apologies for that. Just briefly, I thank you, Justice Curran, for reminding me of the name Walker. I recalled reading the case, but I could not remember the exact name. It would be our position that with respect to the possessory prong, first starting with the police records, the people could not have turned these over at the time that we filed our COC on January 15th, 2020. At that time, Civil Rights Law 50A was still in effect, and I believe this court decided in People v. Brown that we cannot turn over records that we were barred from possessing or disclosing at that time. With respect to the pistol permit, I apologize if my recollection is incorrect, but I believe that the prosecutor had emailed defense counsel, and my recollection was that this pistol permit revocation came up in the context of witness preparation for trial. So I believe he informed defense counsel. The witness just told me this. There is no
Counsel, when did that happen? Was it within the time frame governed by initial discovery?
No, it was not. I believe it was I want to say it was the Friday before this argument took place on the 3030 motion. So that would have been well after the COC was filed and the initial disclosure.
So at that point, if I'm reading the statute correctly, I'm not sure that I am, but that the 3030 relief dismissal on speedy trial appears to be tied to and only tied to a violation of the initial disclosure under subdivision 1, which has a certain time frame by which you comply. So the question, at least for me, when I'm looking at that, issue a speedy trial relief, and since there were no sanctions sought separately, that's the ballgame, so to speak. So with respect to any of these three items, the law enforcement disciplinary records, the pistol report information from family court, and the four witnesses that later identified, was any of that in the possession of the people during the time frame governed by initial discovery, all of which is automatic, but the initial discovery is what's governed by time frame.
No, and Your Honor, I hope you're reading the statute correctly because that was how I interpreted it as well. That's why we have the, I believe it's 245, section 80, all of the sanction options, because the statute necessarily contemplates that discovery is going to continue being turned over. So outside of the initial discovery that, requires the COC to be filed, that's when we get into whether there should be a sanction or some other discovery relief. And that's
Give us everything you have within that initial disclosure time period. You face violating the speedy trial law. Otherwise, when it later comes into your possession, assuming it's within the 21 categories of subdivision 1, you certainly have an obligation to automatically produce it, correct? But
correct.
the remedy for not doing so is under 245.80. Is that what you were trying to say there?
Yeah, Your Honor, you said it better than I could have. But
Am I
yes,
close?
that was my understanding of the statute, because otherwise, why would we have the need for discovery sanctions if the remedy is dismissal under 3030? That second part would never come into play. And again, there was no evidence that the pistol permit was revoked before we had filed our COC. It appears that it was revoked well after, and with the four witnesses, they did not provide their identification, their names, contact information, any of that to the police officers at the time of this particular incident. The people came into that possession afterwards. And I would also note that the court dealt with the four witnesses, the pistol permit, both of those items as discovery disputes. The court never really decided that when it was mentioning why it was denying the 3030 motion. And that's why the court provided defendant with a discovery remedy of adjourning the trial and allowing him to hire an investigator to try to find these witnesses. And there was no contention that that was an inappropriate remedy or that something else should have been done. And unless there are any further questions, I'll rely on my brief.
No further questions, counsel. Thank you. Case 49 and 50, People versus Hall. Counsel, welcome. Can you hear us?
Yes, I can hear you, Your Honor.
You're on mute, counsel.
Yes, Your
No.
Honor. Thank you.
Yeah.
I can hear.
Oh, very good. Now we can hear you too. Very good. Please proceed.
Okay. Good morning, Your Honor, and may it please the court, Sarah Goldbarb on behalf of Mr. Jaquan Hall. Suppression is required because this stop was not justified from its inception. Officers Nellis and Biebernitz testified that they initiated the traffic stop because they observed that the windows of Mr. Hall's Jeep were tinted in violation of the vehicle and traffic law. However, Nellis also testified that he did not know what the vehicle and traffic law spelled out as a permissible amount of tint, and it was his understanding that all window tint was illegal. That was incorrect. Nellis and Biebernitz testified that they did not measure the window tint with a tint meter, and the rest of their testimony on direct accounted to no more than legal conclusions that the tint violated the vehicle and traffic law, which the Court of Appeals said in Niktalov was insufficient to establish that police had probable cause to stop a vehicle on the basis of a traffic violation. When directly asked by defense counsel during cross-examination, Nellis did confirm that he could not see the driver of the vehicle through the window. However, that statement is ambiguous. It wasn't clear whether Nellis meant that he couldn't see a person through the window at all, or whether he just simply couldn't identify who the driver was.
Counsel,
Yes.
I'm sorry, but if we accept that argument that it's ambiguous, isn't that a question for the trial court to have evaluated? I mean, here the trial court credited that testimony, didn't it?
I believe it did, Your Honor. Yes.
So the trial court credited Nellis because that's probably the only fact that came out of those 3 days of suppression that supported the determination that there was a reasonable belief that the defendant had excessively tinted windows, correct?
That is correct, Your Honor, but I think that statement really has to be read in conjunction with Nellis's other statement that it was his belief that all window tint was improper. And so for that reason, we would ask that this court.
Counsel, let me ask you a question, just so I can understand your argument more clearly.
Mhm.
Is it your argument that at most the testimony demonstrates that, because when I'm reading the cross-examination especially, the officer's saying that they're within 10 or 15 feet of the window and that it was dark out and that the officer couldn't see the driver, right? Would you agree with
Yes,
that?
that's correct.
Yeah. And that lends itself if you just look at that, that lends itself to the argument that the police officers have probable cause if at night they can't see the driver because it's dark out. And that certainly isn't enough basis to establish probable cause. You'd agree with that?
I would agree with that, Your Honor,
Yeah.
yes.
So we need to look at something else in the record relative to the tinting, that the officers testifying directly that the reason I pulled over this vehicle was because the tinting of the windows stopped me from being able to see the driver. Are you saying that there is testimony in this record that demonstrates that the officer clearly testified that the reason he pulled this vehicle over was because the tinting stopped him from being able to see the driver?
I don't think that that's a reason why he pulled the car over, because that wasn't something that he testified to on direct examination. It was only on cross, when the defense attorney was probing for more information about this tint, that it came out that the officer is saying that he couldn't see the driver. And again, that's not clear whether he couldn't see a person at all or just couldn't identify this driver. So I think the reason that Officer Nealis said he pulled over the vehicle was because he observed what he thought was an illegal window tint, but he thought all window tint was illegal. And so that basis is not sufficient for the stop.
Even if he was wrong about the law and the tinting, and if we read the record to say that he pulled the vehicle over because of the tinting, even if he was wrong, but he believed in good faith that that was a justifiable reason to stop, isn't that enough?
If he believed it was a justifiable reason for the stop, then it might be enough.
He believed in good faith that he had justification for pulling the car over because he saw what he thought was illegal tinting and he pulled the car over. Is that enough for the stop to be based upon probable cause?
I believe it would be, Your Honor. However, if that's what this, I believe it would be, Your Honor. However, that's why we would ask this court to consider the second part of our argument as well. If I could move on to that part, which is that even if this court finds that the initial stop was proper, suppression is still required because police did not have probable cause for their warrantless search of the Jeep. The trial court found that the search was permissible under the automobile exception. However, the circumstances of Mr. Hall's arrest did not provide police with probable cause to believe that evidence or contraband would be found in the vehicle. Nellis testified that he searched the Jeep because of the drugs found on the porch and because of Mr. Hall's failure to comply with the traffic stop. However, the video footage from Nellis's body-worn camera played during the hearing shows that only the top portion of the knotted bag was visible through the porch slates. Based on the portion of the bag that was visible, it's unlikely that Nellis or any of the other officers were able to draw a meaningful conclusion regarding whether there was contraband inside the bag until after it was removed. Nellis even confirmed that the video captured exactly what he saw. And after he observed that plastic bag, he went immediately back to the Jeep to search his vehicle. So this happened before the evidence technician came to remove the bag from the porch and was able to identify what was actually in there. The search of the car happened before all of that happened. And so accordingly, police did not have probable cause to believe that contraband would be found in Mr. Hall's Jeep.
Counselor, let me, I'm sorry to have you go back to this point, but I'm looking at your brief now and I want to make sure I understand your argument in the brief.
Correct.
As I read with respect to the probable cause to stop, as I read your brief, and correct me if I'm wrong, your primary argument, if not the only one, was that the one officer testified as to a misunderstanding of the law, that is, that any tint was sufficient. Is that the thrust of your argument? That he had a misunderstanding of the law?
Correct. The thrust of my argument is that Officer Nealis did not understand what the vehicle and traffic law spelled out as a permissible amount of tint.
Okay.
And so in his mind, any window tint, even one that might have been legal, was improper.
But in your brief, you also acknowledged that that upon the defense counsel's questioning, the officer specifically said that he could not see the driver in the vehicle. That's how tinted the windows were, and that's what he said, right? And you agree with that?
I do agree with that. He said that he couldn't see a person through the window, but it's unclear whether he meant he couldn't see anybody at all, whether there was a person in there or not, or whether he just couldn't identify who the driver of the vehicle was.
And in your brief, of course, you cited to the Court of Appeals recent decision, and I'll mispronounce it, in Nektalov from May of 24. And in there, the court, if you recall, gave examples of where the evidence would be sufficient. And the court said the detective, for example, in that case, did not testify that the windows were so dark that he could not see into the vehicle. And cites to Biggs, Brown, and Collins from the Appellate Division. Doesn't that example fit here because the officer testified he could not see the driver in the vehicle due to the tint? Isn't that enough under those cases?
That is correct, Your Honor, that's what the Court of Appeals said in Nektalov. However, the court said that their decision might have been different had the detective testified to something such as, they couldn't see the driver of the vehicle. And so I think the use of their word might indicates that there could be a situation where one of those things was testified to, but it still wasn't enough. And I think here, even though he testified that he could not see the driver of the vehicle, I think the fact that this officer was was wrong on what the law permitted enters into that territory where it might not have been enough.
Thank you, counsel. Anything further?
No, if there are no other questions, then I rely on my brief for all other points. And I ask this court to suppress the evidence found in the Jeep, vacate Mr. Hall's conviction, and dismiss the indictment. Thank you.
Thank you. Counsel, proceed.
Thank you, Your Honors. Elizabeth Dannon for the people. Your Honors, in respect to the defendant's first point, we would point out that there was not just one officer at the time of the traffic stop who observed an illegal window tint. According to his testimony, there were two. There was Officer Babernetz as well, who did testify that he knew how to use a tint meter. He had a tint meter. He believed the tint was illegal, and he did testify to a correct understanding of the law in that there was it needed to be 70% or more.
Counsel, remind me, was the second officer's testimony that he saw the tint before the car was pulled over or after it was pulled over?
Yes, I believe he saw it before it was pulled over. So yes.
Did he testify that he thought the tint was illegal when he saw it before the car was pulled over?
It said, what, if anything, did you observe of this vehicle? It had illegal window tint in violation of the correct V&T law section 375-12A-D2. So he testified to a correct understanding of the law as well, Your Honors. And I would state, in the lens of Nektalov, it would have been, preferable if there had been more elicited on direct examination in regards to these officers' knowledge and observations before attempting the traffic stop. But we would submit that is enough. Also, with regard to Nektalov, in that case, the Court of Appeals, it was brought out that the driver of that vehicle immediately pulled over. Here, there was no such case. The driver engaged in several other violations and turned off its lights. And so there was also additional issues with this driver. Moving on to point 2, unless you had any other questions.
No questions, counsel.
Okay, thank you. Yes, I would just point out that there is a long precedent of, seeing a plastic bag with a white powdery substance in it that does give probable cause to believe that there is drugs. I would rely on point 2 of my brief for that. And just briefly, Your Honors, in regards to the defendant's argument that he should be restored to drug court. We would just point out that the defendant points to a number of transcripts which were not in the record, so were not available. So I relied on, and I would request that the court also rely on the information in the pre-sentence report rather than whatever may be contained in the transcripts that were not included in the record.
Very good. Thank you, counsel.
Thank you, Your Honors.
Case 53, People versus Wright.
Morning. Please.
Good morning, counsel. Proceed.
Tanya Plank for Adrian Wright. Here, Mr. Wright was denied the effective assistance of counsel. On the record, there was no possible strategic reason for his decision to request a second-degree robbery charge and not a third-degree robbery charge, given that he never made any argument that there was a gun that wasn't loaded.
Doesn't the record indicate that the defense counsel here specifically advised the court that he was pursuing a strategy to not request that?
The court did, during the charge conference, the court pointed out that he made all these arguments during summation that the gun wasn't loaded, or that there was no gun at all, not that it wasn't loaded. And then he asked, do you wish to request a lesser included, by which he meant third-degree robbery? And defense counsel, I believe the court said, I assume you have a tactical reason for not wanting to request that. And defense counsel said yes. So he said yes, but he didn't specify that he really had a strategic decision, and it doesn't make any sense.
What's the difference between a strategic decision and a tactical decision?
It's just a term, I think. I don't know that there is a real difference, but I'm not sure. It just doesn't make any sense that he would have requested the second.
It may have been a wrong tactic or strategy, right?
Right, definitely. It may have been wrong, but there has to be a logical reason. I mean, there's just no, if he would have requested no lesser included, if he wouldn't have requested the second degree, then that would be valid. That would be a valid strategy, but he requested the second degree and not the third degree. So he placed the burden on himself to prove the affirmative defense. He exposed his client to the second violent felony offender with a much longer sentence. So there was a lot of prejudice here. And there was a strong likelihood of success because of that colloquy in the charge conference. And then I would argue under the standard of review, whether viewed in the light most favorable to the defense, whether there's a reasonable view of the evidence that he only committed robbery 3. And I would argue that there is a reasonable view of the evidence here, taken in the light most favorable to defendant, because he could have, there was no showing of a gun on the surveillance tapes.
But wouldn't that be a reason not to request robbery 3 then, as a tactical decision for the defense attorney? That why give them something you can convict my client of here? I can beat robbery 1st or 2nd, but I can't beat robbery 3rd. If the court doesn't charge that, I can get him acquitted.
Well, but his arguments all throughout were that there wasn't a gun at all, and there was no showing that there was a gun at all. So then requesting robbery 2, it just didn't make sense. And then it confused the jurors, which understandably so.
Is trying to confuse the jury with the affirmative defense perhaps a legitimate strategy? Maybe seeking an acquittal as opposed to virtually guaranteeing his client of conviction, lesser included?
Well, I would argue it's not a very good strategy, and he would have had a much better.
But they bought the affirmative defense, the jury did, right?
Well, yes, and I did include the 330, the issue with the 330, or the from the 330, so the colloquy there. So the jurors did have a problem, and they were confused. And that's shown by the 330.
We'll take a look at that, counsel. Anything further?
No, thank you.
Good morning. Marty McCarthy for the People. Tactics is what wins battles, and strategy is what wins wars. But when we use them interchangeably. Just to answer your question.
Thank you, counsel, for clearing that up.
Yes, no problem. Clearly, there was a strategic reason for counsel's actions in this case, and this is also a single error case, so you have to look at this issue as having being dispositive, and it's clearly not dispositive. When you look at the evidence, yeah, there was no gun on the video, but the robbery didn't occur on video. It occurred in the room where there was no video.
And all witnesses testified what the gun looked like in various degrees. There were obviously some said silver, some said black, some said different sizes, correct?
Which happens all the time, but yes, they all described a gun. And I believe they all described a semi-automatic gun. So, and when you look at the case in my brief where I believe it was Rivera, where robbery third was appropriate, the charge there was appropriate because the witnesses described something that definitely could not have been a gun, right? Here, every witness described what was a gun. When the judge made those comments that defense counsel is relying on in the 330, I believe what the judge omitted was loaded. So it was reasonable for the jury to come to the conclusion that the gun wasn't loaded, not that he didn't have a gun. Because there was no evidence to the contrary that he didn't have anything other than a gun. And when you look at it sort of commonsensically, there's 5 gentlemen in this room, they're grown men, and there's $8,000 worth of money on the table. It doesn't make any sense that he would have been able to complete a robbery without displaying a gun. So if there are no other questions.
No other questions, counsel?
Thank you.
Thank you. $556, $557. Nadia versus Ashley.
Warren, may I proceed?
Hold on a second, counsel. We gotta make sure everybody's here and available. Counsel, can you hear us?
Yes, I'm just trying to get my video activated.
Very good.
Thank
you. Counsel Kuntz, can you hear us?
I can, thank you.
Very good. We appear to be missing Counsel Burkhardt, according to my notes. And we'll call the case. Proceed.
Thank you, Your Honor. May it please the court, Thomas Babel on behalf of Appellant Ashley M. The first issue I'd like to discuss this morning is that the court failed to engage in age-appropriate consultation with the children. The Family Court Act requires the court to engage in age-appropriate consultation in guardianship matters that are intended to resolve a neglect proceeding. This is a requirement of proof of the Family Court Act. Contrary to what the argument they have ceased, the statute requires age-appropriate consultation regardless of the age of the child. Although requested by Ashley's attorney, the court failed to hold a Lincoln hearing. The court also failed to elicit the children's preferences from the AFC, who in her closing stated only, "My kids don't want to go there," without reference to either parent. They love spending time with her, presumably meaning Ashley, but that she, the AFC, would request no overnights. Here, the AFC did not clearly state what the children's preferences were. And because of this, and because there was no Lincoln hearing, there was no age-appropriate consultation, and the matter should be remanded to lower court for age-appropriate consultation. The second point that I'd like to discuss is that the family court in this particular case lacks subject matter jurisdiction over the case. Family Court Act 661, entitled Jurisdiction, requires that in all guardianship cases concerning children in foster care, these children are clearly in foster care, the permanency goal for the foster child must be referral for legal guardianship. It's undisputed here.
Counselor, let me just stop you there for a second. Just to set this in context, we're in the midst of an Article 10, right? When the kinship guardian petitions are filed.
There is an Article 10 proceeding regarding yes.
There's an Article 10, and then we have the joint kinship guardian petitions filed, and then at the permanency hearing on February 9th, that's where the court changes the goal, doesn't it?
No, the court does not change the goal. The goal of the February 9th hearing remains return to parent. They also allowed for concurrent planning for permanent guardianship, but that is different from, and it's the case law is particularly different from the permanency goal, which remain return to parent here. If the permanency goal were to remain returned to parent, a parent might not object to that. However, if it's referral for legal guardianship, it's more likely that the parent would object to that. And the article, section 661 requires a permanency goal of return to parent. Actually, the way I read it says prior to filing a petition for guardianship, but there is some case law that might be interpreted that it could be changed at a joint hearing, which was not had here. And in fact, in the decision, the court concedes that the permanency goal was return to parent, and they said that even her decision, she conceded that. So because of that, I would ask that the order be vacated and the petition be dismissed. The next point that I'd like to discuss is that the family court failed to hold a required joint hearing. The Family Court Act necessitates a joint hearing on guardianship when there's a Article 10 proceeding with guardianship with either a permanency hearing or a dispositional hearing.
On this issue, I'm looking at the statute that we should be looking at is 1089-A, right?
Yes, 1089-A is with regards to permanency hearings, and 1055B is with regards to dispositional hearings, which are the two options available.
And you're referring to that, I won't go through the subsections, but the one sentence that talks about the court has made the following findings after a joint hearing.
Yes, that is part of the language, yes.
Okay, so is it your position that in these situations, I think when there's a neglect proceeding and a kinship guardian proceeding, that partial summary judgment on the issue of extraordinary circumstances is never allowed under the law, and that a joint dispositional hearing is always required on both extraordinary circumstances and the ultimate disposition?
Yes, and it's clear because of that, the extraordinary circumstances have to be proven at trial, because if they didn't exist at the time of trial, then they wouldn't exist for the purposes of the granting of guardianship. So that's a different point, but yes, I do agree with you.
Broad rules. You saw my emphasis.
Yes,
on the question,
yes.
And I want to make sure you're committing to that broad rule, that's what you're asking us to do. Broad rules are difficult to get, particularly here, isn't it? Because the finding of neglect is really not disputed, and our case law says that finding of neglect is enough to establish extraordinary circumstances.
No, I disagree with that, Your Honor, respectfully, because what the statute says, the statute contemplates there being a finding of neglect, because these are children that there's already been a finding of neglect. They're in foster care. So the statute contemplates there's already been a finding of neglect. So how, if that constitutes extraordinary circumstances, how then would the statute require that extraordinary circumstances be proven at trial?
Counsel, let me see if I frame this procedurally again, because this is where I'm coming from. There wasn't a trial because there was a motion for summary judgment on that issue.
With regard
to standing and extraordinary circumstances, there wasn't a need to have a trial because the court did indeed grant summary judgment following the motion return.
There was a trial, Your Honor.
But extraordinary circumstances were resolved on motion.
That is what the lower court did. Yes, that's correct.
Right. And it was a motion without opposition.
And that's correct. And I go.
So you're faulting the court for not having a trial when the court had already resolved the issue on summary judgment.
Well, the court had a trial, Your Honor. What I'm saying the court should not have done, they should not have granted that motion, because the statute requires that be proven at trial. Because if the extraordinary circumstances do not continue to exist at the time of trial, here this case was pending for a year.
I understand. Just so I understand your contention, that your position is the court could not have substituted the trial with the motion for summary judgment. The motion was made that there were no questions of fact by virtue of the prior neglect finding. Well, there was no opposition.
That was the argument, yes. And I would note that my client was unaware of the motion until just.
That's a separate issue.
That's a separate issue. Yes, Your Honor.
In terms of procedure, I mean, this is at least for me, a challenging procedural case.
Yes, I agree.
You've done a nice job spelling out the statutes here, and we follow, but yeah.
Counsel, let me ask a question. You just indicated that the mother did not object on the motion for summary judgment.
Well, she was unaware of the motion for summary judgment.
Right. And I think there was a February 9th appearance at which the motion was decided. Mother's counsel acknowledged receipt of the motion papers, I believe, noted that he had not yet had a chance to discuss the motion with mother, but nonetheless argued that the mother had completed all of her required services, specifically her substance abuse counseling.
That's correct, Your Honor.
Seems to be in the nature of opposing.
Well, yeah, I apologize. You are correct, Your Honor. He did oppose it to some extent, but the client was completely unaware of it. He should have. I mean, he should have opposed it in that the court can come to this conclusion at the point, because the statute requires that be decided at trial, but that was not one of his objections. But yes, he did contest it to some point. I agree with Your Honor. Back to the joint hearing issue. In this particular case, the applicable hearing would have been a permanency hearing because there was a permanency hearing scheduled for that date. The order, in fact, said that they had a joint permanency hearing, which they did not. The court clearly disposed of the necessity of the joint hearing because they had already decided the guardianship matter. What's really important in this particular case is why a permanency hearing was required is because first, the permanency goal was never changed. So if the permanency goal was changed at the hearing, perhaps then there would have been the 661 jurisdictional issue would have been cleared, but that didn't happen here. And because there was no hearing, certain evidence wasn't able to be introduced because at a permanency hearing, the evidentiary standards are different. Hearsay is admissible as long as it's relevant and material. In this particular case, certain evidentiary material was rejected because it didn't have certain certifications when it clearly would have been admissible.
Let's be clear about that issue. There was no attempt to admit those uncertified records until apparently the after proof had been closed and during oral argument. That was the court's reasoning there, not receiving that evidence. Well,
it was in a closing statement, and the court's reasoning for not receiving it wasn't certified. At that time, the attorney and this goes to the ineffective assistance of counsel claim as well. But at that time, the attorney requested that the record be kept open, as the county had done also previously, and the court denied that request. To certify the records. The court rejected them because they were not properly certified under the statute. And the court conceded that they didn't have a permanency hearing. They said right on the record, we're going to dispose of the necessity of permanency hearing takes have already decided the guardianship issue.
Counsel, you should begin to wrap up.
Okay, I'm sorry, Your Honor. One just really quick, the trial court also erred when it restricted Ashley's visitation. Neither the guardianship provisions, Article 17, or the Circuit Courts Procedure Act or Family Court Act permit a court to restrict the powers of a guardian. Yet that's exactly what the trial court did here in this case by restricting the guardian's ability to make those decisions for herself. This is especially egregious in this case, and the appellant would argue an abuse of discretion, as there were no concerns regarding the mother's unsupervised visitation. And all parties.
Counsel, this point is raised in your brief, correct?
Yes, it is, Your Honor.
Yeah, you should begin to wrap up.
Okay, all right. Thank you.
Counsel, proceed.
Attorney Lisa Cuomo for Onondaga County. Judge, I did note in my brief that as far as the Lincoln hearing is concerned, the defense counsel or the respondent's counsel didn't request a Lincoln hearing. He spoke just cursorily about a Lincoln hearing a year prior, but never made any kind of an application for a Lincoln hearing in this proceeding. In addition, it is not required to have a Lincoln hearing in a kinship guardianship proceeding. With regard to the partial summary judgment, again, I would agree that the court has already made an adjudication that the appellant had been found to have violated Article 10, and there had been a dispositional hearing and subsequent PPH hearings in which they determined that ma'am had not complied with the announced and unannounced drug screens and also was still living with the father. As far as talking about the goal was concurrent planning in February. More specifically, the goal was return to parent with a concurrent plan of kinship guardianship. So I would say that that is absolutely proper. And then when kinship guardianship was determined, it was not necessary to continue on to a PPH hearing at that time. And if I may, just one more point, I note that the law guardian requested that there be some unsupervised visitation, and I would oppose that at this time. And I would note that the court had enough information during that time to make a substantial finding that supervision should be supervised, as ma'am had not complied not only with the announced and unannounced drug tests, but also she did not take the hair follicle test that the court had ordered.
Very good. Thank you, counsel.
Thank you.
Counsel Const.
Rebecca Const on behalf of the guardian aunt, rather than reiterating everything that Ms. Cuomo just stated, we agree that the court correctly made the determinations that they did, that the proper hearings were held in the proper order, that the AFC participated throughout the hearing, and she did state the children's wishes many times throughout the hearing, and she definitely had consultations with them. After the finding of neglect, that was sufficient to grant the aunt standing for the guardianship petition. And as far as the permanency goals, as Ms. Cuomo stated, they were concurrent, and that was sufficient. And unless the court has any further questions, we will rely on our brief.
No further questions, counsel. Thank you.
Thank you.
Case 58, Kim A.F. versus Alexis M. VR. We'll deem that case. Oh, no, they're coming on video. Very good.
Can your honors hear me?
Counsel, we can hear you.
Good morning. Good morning.
Mr. Otis, before you begin, Mr. Otis, can you hear us?
Yes, thank you.
And we can hear you. Please proceed.
Wonderful. Your honors, good morning. May it please the court. Judge, the thrust of this appeal can be, I think, categorized into three categories. First, the appellant argues that the court below erred in ordering the genetic marker test. I respectfully submit to your honors that the court below had full evidentiary hearings with regard to the best interests of the child, fully considered the issues of collateral estoppel, latches, and whether the Medero presumption in this case precluded the ordering of the genetic marker test. Full evidentiary hearings were held, and the court determined based on those evidentiary hearings that a genetic marker test would be appropriate. The mom failed to rebut that presumption, and the genetic marker test was ordered. There is absolutely nothing wrong with the court's analysis or the procedure that was taken to arrive at the decision that genetic marker test was in the best interest of this child. I ask your honors to affirm the decision of the lower court.
Thank you. Oh, go ahead.
The appellant also argues, your honor, that there were some evidentiary mistakes made in the court below to refuse to admit certain evidence of prior bad acts. The refusal was the same for both parties. Therefore, there's no error that can arise from this. And the court also, again, had the chance to determine and observe the nature and tenor of the parties. And I don't think its determination should be lightly disturbed. The ruling was fair for both sides. Third, the appellant argues that the court erred in admitting the genetic marker test. Again, there were full-blown motions on this. The court fully considered the issues of whether to admit the genetic marker test, and given the balancing of the factors that the court did, which were all proper, determined that there was no reason not to admit the genetic marker test. I ask your honors to affirm that decision. And then finally, Judge, I think it's very important to tell the court about some of the conduct of the parties after the issuance of the genetic marker test. After the issuance of that test, the parties both moved to New York. Mom had a neglect adjudication in New York, and for a while, the child was placed with her mother, the maternal grandmother. My guy timely and appropriately sought to be the father of this child from birth. The parties all moved back to the state of New York. And in November, CPS removed the child from mom based on allegations of suspected drug use. Mom voluntarily consented to the removal of the child and for the child to be placed with the father, the father in the genetic marker test. And that was a voluntary stipulation that she entered into. She did not contest the paternity of the child at that point. So really, the appeal here is moot. The child has been placed under an end docket with my client, who is sole residential custody of the child, is in fact the supervisor for mom's parenting time. At this point, the conduct of the parties subsequent to the bringing of the appeal have made the appeal moot because there's really, under Alyssa C., the paternity issue is resolved, and the decision of the court below that's being challenged does not substantially affect the rights of the parties. So unless your honors have any other questions, I rest.
Very good. Thank you, counsel. Mr. Otis?
Yes, thank you. I'm here on behalf of the child. Thank you for hearing me today. I was first assigned to this matter on the appeal. It doesn't strike me as a particularly close case regarding the validity of the contested trial order. The underlying facts are fairly clear, and the court correctly applied the common law presumption of legitimacy against the statutory preference for testing and correctly assessed the equities and the child's interests. So I think I really have anything to add to my legal analysis in my brief unless there are questions, but by way of update, I would just affirm there was a second neglect petition that's been filed against the mother in this matter, resulting in placement of the child with the father. I met with the child. He appears happy and thriving in the care of his father, where he's now residing with his similarly aged brother. So other than that, I wouldn't take up any more of the court's time unless you have any questions. Thank you.
Good. Thank you, counsel. Case 59, Abdoc versus Abdoc.
Good morning, Your Honors. May it please the court, Allison Bates as appellant, attorney for the children. I submit respectfully that the decision that you make today will be one of the most important decisions that you make today.
Ms. Bates, let's address, for my sake anyways, the standing issue for AFC. You've briefed it extensively.
I did, Judge, and that's why I think that's going to be one of the most important decisions that you make today.
So you're really asking us to abrogate our prior case law, because if we apply Lawrence, it seems to be dead on.
Well, Judge, there's been several situations where this court has addressed standing and has noted that there are circumstances where giving an AFC standing to appeal is appropriate. And I submit that this circumstance here would be one of those circumstances. I know that the court has formally dismissed matters where there was a stipulation between the parties or where a petition was dismissed. But the difference is that in this case, there was an order that was modified. And the party that is most aggrieved by a modification of custody order is the children. And I think the whole issue of standing really focuses on, whether it be in a criminal matter or family court matter, the aggrieved party. So
we really need to know what the status of the mother is and her ability to, participate in the order that the AFC is looking to change. And we don't really know that, do we?
Well, Judge, in this case, just like in the Muriel matter, the mother did submit an order, a letter to this court in support of the appeal here today.
To the court or to you?
To the court.
Which court?
To this court. The mother, Miss Abdoc, did submit a letter just as in the
Where is
Muriel
that?
matter.
You have a record site on that?
Judge, it was submitted shortly, either shortly before or after I perfected the brief. I was aware the letter was sent to my office. I filed it with NYSIF. And was told that it needed to be sent directly to the court. And so the mother and my office both sent that letter directly to the court. But I would submit, Judge, that letter, that whether or not an AFC has standing shouldn't hinge on the actions of the parents. When the chief judge changed the ruling on attorneys for the children in 2008 and shifted the focus from a law guardian to an attorney for the child, our practice really changed. We have all the same rights and obligations as an attorney, but this court, unlike every other department in the state, has not afforded attorneys for the children the same rights to appeal matters. I'm not asking you to entertain any appeal by any AFC that's ever filed in this court, but I do submit that there are limited circumstances where it is appropriate, where an attorney for the child has taken a position and their clients are capable of voluntary and knowing judgment, and the court makes an order against the position of the children. I do believe that the attorney for the children should be able to come before this court.
I'm sorry to interrupt you again, but back to the Lawrence case. It's a custody petition. It's everything I looked at. I was on that case.
But in that case, Judge, the petition was dismissed respectfully. In this case, the petition was not dismissed. An order was changed, and these children's lives and what they had been used to was abruptly changed by the trial court judge. So I would submit that that's the difference in the Lawrence matter.
But then we have other cases you've cited too that seem to go the other way. I guess what I'm really driving at is, I think the only way we get to allowing you to have standing here, given the lack of any record evidence supporting it, is to abrogate our prior case law. And that's a tall order because we've consistently taken that position, I think, in a lot of cases. I know Mariel's different. I was on that too. And I know you try to equate this case to that, but it's not Mariel. The record evidence is much different. And I'm not suggesting for a second, Counselor, that this has occurred in this case. One of my concerns in a situation like this is that you become a mechanism to provide a party a free lawyer. That is, that you could end up, this can play out in a whole bunch of different ways. The losing party could always say, hey, the AFC is with me, so I'm going to let the AFC pursue it.
Well,
And
I
it just
understand.
doesn't seem fair to the other side then either. That's some of the things, that's one of the things that's bothering me.
I understand, but the parents have independent rights to free counsel. And frankly, most of the parents in family court end up qualifying for free counsel. And I think the attorney for the child has a very clear responsibility to be advocating only for their client's position. It would be highly unethical and improper of me to serve as a vehicle for a parent's attorney. I'm not here today at the beck and call of Mr. and Mrs. Abduck. I'm here because my 4 clients, who I spoke with again last night, were not happy with this order and are still not happy with this order. They still have not adjusted to this order. If you're unsure today, I implore you to talk to, as I have, over 1,500 children in my 15 years as an AFC, and ask them what it's like to be a child whose parents live in 2 different houses. Because I can tell you from personal and professional experience that it's not easy. And while I submit to you that based on the limited amount of time that passed between the controlling order and the petition, the lack of testimony regarding any real change in circumstances, and discounting the acrimony between the parties, because any 2 litigants who end up on the 3rd floor of Hall of Justice, there's acrimony, right? And while I submit the trial court failed to articulate a best interest analysis, the real issue here is standing. So whether or not you agree with me on substantial change of circumstances, whether or not you agree with me on best interests, I beg the court to really consider the standing issue. I'm hearing you about prior case law, but case law evolves. And the statute has evolved since 2008. And the case law has evolved since 2008. And this court has told me in other cases that you're giving me a chance, that there are circumstances where it's appropriate. For example, in the Joey LF versus Jared AF matter, the court found there was no standing because there was no changes made to the order. But this court said, and I quote, under the circumstances of this case, there is no standing. So you're telling me that there is cases where it's appropriate for an AFC's to have standing. So whether you reverse the order or not, whether you remand the order for an articulation of best interest, because that didn't happen, that wasn't in the decision, I'm asking this court to finally take a firm and final position on standings for AFCs in this department, as every other department in the state has done.
We'll take a look at that, Counsel. Anything further?
Unless you have any questions for me, I would otherwise rest on my papers, and thank you for your time today.
Thank you, Counsel.
Yep, thank you.
Case 62. 3750 Monroe Avenue Associates Inc. versus New York State Department of Environmental Conservation. Counsel.
Good morning. If it please the court.
Hold on 1 second, please. And I know I just kind of prompted you to start. Counsel, can you hear us?
I can hear you. Can you hear me?
We can very well, Counsel. Okay, we're ready to go. Proceed, Counsel.
Yes, Your Honor. Please the court. I'd like to start out and talk very briefly about the underlying dispute here involving the alleged requirement that my client provide financial assurance for a non-selected remedy under the Brownfield Cleanup Program. And then I'll talk about the alternative dispute resolution issue. The BCP, the Brownfield Cleanup Program, is intended to encourage parties to voluntarily remediate brownfield sites for reuse and redevelopment. It's based on the reasonably anticipated use of the property. In other words, it's not a perfect cleanup. It's not a cleanup back to exact pre-existing standards. You take a look at what the property is being used for currently, and then you design a remedy that will clean it up to those use standards. For example, In this particular case, it is a property zoned industrial commercial. There is no requirement under the BCP that the client clean the property up so that you could put a childcare center there or a nursery or even residential home. So,
Counselor, I think we understand that part of this.
okay,
So what we've got is a 9-acre parcel with a big building on it,
right?
6-acre building. And there's an issue underneath the building that the DEC is concerned about.
Indeed, there is.
And there's some remediation work, but it isn't completely cleaned up under the building.
That's correct. The selected remedy is to put a cap to provide treatment for anything that emanates from out from under the building, and to continue that along with natural attenuation.
And the DEC says for you to continue to stay in the brownfield cleanup program, you're going to have to post some cash or some surety to make sure that what from the DEC's perspective, that there's resources to finish what you started at the property.
To be precise, they are saying that we are obligated under RECRA to take corrective action, and that corrective action includes posting financial security for an eventual cleanup of the property when and if it is either vacated to the point where you can get access to all that space inside to remediate the source, or
let me finish there. Just that frames the issue, because it seems to me what you're arguing is that your client was removed from the program without cause. There wasn't a basis for the DEC to impose any financial surety requirement on our client under our program and our agreement.
No, that's not exactly correct. There was a requirement, and there is a requirement, and we concede that there is a requirement that we provide financial assurance for the selected remedy, meaning after you go through and discuss the alternative remedies, once a remedy is selected, as it was in this case, okay, we are prepared to and have indicated on numerous occasions, as reflected in the record, our willingness to provide financial assurance for the selected remedy, which is what the brownfield cleanup program requires. What the DEC is saying, because we never went after the original generator and permit holder of the RECRA permit, we basically let them skate for 40 years. We closed that site without ever doing any water testing, soil testing. And in fact, the record does not even reflect that anybody from the DEC ever went there. They accepted a letter from an engineering firm hired by the generator that said, we cleaned it up, it's broom clean. So based on that, they closed it, and then they ignored the generator, who is the liable and morally and legally responsible party under the RECRA program. They let them skate for 40 years. And only when they realized that they had been so negligent as to let them go without any kind of corrective action, did they start looking at us, because we are now the current owner of the property, and voluntarily entered in.
Well, there's a little more to that, because 2 of your principals were prior site owners.
2 of the partners.
But you're getting to the merits, because the DEC says those issues, all of this dispute should have been addressed in the administrative proceeding that you forewent.
Okay. Here's the problem, okay? Number one, the language of the brownfield cleanup agreement specifically says that this will not apply to remedial activities. The brownfield cleanup program, the brownfield cleanup program and the alternative dispute resolution provision is only dealing with remedial activities. Now, remedial activities under the regulations are defined. They do not include financial assurance. Financial assurance is to provide a financial assurance for a remedial activity. They're not the same. The judge seemed to conflate them and say, well, they're part and parcel. So in other words, you should have filed a request for alternative dispute resolution. Second of all, the DEC told us several times that this RECRA liability was not subject to alternative dispute resolution. It's in the record, okay? As early as 2016, they told us that. And You have a letter from Frank Sowers. He lists things that are not subject to dispute resolution and things that are. And one of the things that's not subject to dispute resolution, if you look at page 154 of the record, is associates' alleged rec reliability. So they're telling us in one breath, you cannot dispute this in an alternative dispute resolution process. And they repeated it, okay? And now they're saying, oh yeah, you should have because the regulations say you should have. But what the language, I think it's important to note that the language of the paragraph in the BCP agreement, and I'll read it, notwithstanding any other rights otherwise authorized in law or equity, okay? Meaning these regulations that are generic in nature. Any disputes pursuant to this agreement shall be limited to departmental decisions on remedial activities. In no event shall such dispute authorize a challenge to the applicable statute or regulation. So in other words, they're saying you have a contract and your contract limits what you can focus on to invoke the alternative dispute resolution program. And on top of that, they say, even if you wanted to challenge this, you waived it. It's not subject to dispute resolution. So this argument that somehow we waived our rights, they completely ignore the language of the contract and basically say, you know what, there's a regulation that trumps that. So logically, what they're saying is you should have gone to alternative dispute resolution. But if you did, we're going to tell you, number one, you can't dispute a remedial activity, and financial assurance is part and parcel to that.
But
And
you
number
never
two,
disputed that at the time. Your client never said, look, you're not allowed to bring this to, this is something you've come up with on appeal.
well, we did say that.
At the time when the 15 days was exhausted and when those time limits went by, you in the 30-day period, you said, DEC, you don't have this authority to do this.
I said, you told us that this is not subject to dispute resolution. I did not raise the language, the specific express language of the provision in the BCP, but that was certainly an issue as well.
But what about, isn't there a Court of Appeals case that says that they're required to do this unless the agency's action is wholly unconstitutional?
Who were required to do what?
Apartments v. Buffalo Sewer. Are you familiar with that case?
I'm not, Your Honor.
Okay.
What does that case say?
It says that unless the agency's action was challenged as unconstitutional or wholly beyond its grant of power, resorting to administrative remedies would be futile or its pursuit would cause irreparable injury.
Well, I guess it would be futile if they've already told you that it's not subject to dispute resolution and it doesn't cover financial assurance issues.
But they are saying because now they're saying, at least in front of us, that, yeah, you should have done that.
Yeah, now they are.
So you're saying that they would have told you, you believe they would have told you that at the time, so that's why it's futile.
Of course.
Okay.
I mean, it's a catch-22.
Counsel, they do, there is the record, for instance, the letter December 16th, where they indicate if you're not happy with what we're doing, you can invoke the dispute resolution. They notified you, your client.
Let's talk about that a while, okay? I'm glad you asked that. This was a stealth campaign to lull us into waiving our rights under the alternative dispute resolution program, if, of course, you ignore the actual language of that provision. The letter that he refers to, the 1997 and 1998 letters that Mr. Sowers in October of 2016 based this waiver argument on, was a statement that this site is subject to RCRA, okay? This somewhat unexceptionable statement, this site is subject to RCRA. So what does that mean? Does that mean you're going to have to be required to post financial assurance for a remedy that's not even part of the BCP program? I wouldn't say so. Well, they realized that that was kind of a weak argument too. So what do? They go back and they say, well, no, it's really, you got to look to the December 16th letter. The December 16th letter from the DEC to Mr. Norrie, we said, in the revised report, please include a viable option to remediate the source under the building should the building become vacant, demolished, or subsurface otherwise made accessible. So what they're saying is, in your remedial investigation work plan, include a viable option for cleaning up the property perfectly. The problem with that is we're required, when we prepare a remedial investigation work plan, to include a perfect option. That's required by the regulations. It doesn't mean that that's the option that's going to be selected. And in fact, it was not the option that was selected, but you're at least supposed to include that as a viable option, which we did. And the remedial investigation work plan was approved by the DEC, and the selected remedy was something less than a perfect cleanup. It makes no sense. It makes absolutely no sense to have a BCP program where you will allow a participant, whether it's a volunteer or a participant, whether you will allow an applicant to do a less than perfect cleanup, okay, as would be required if we were in the inactive hazardous waste site program. We're not. We're in the BCP. It's an alternative. And it's an alternative that allows you to do something less than a perfect cleanup. It would make no sense to say, we're going to let you in this BCP program. We're going to let you do something less than a perfect cleanup. Clean it for the reasonable anticipated use of the project. And then say, oh, and by the way, you've got to pay for and put away money to pay for a perfect cleanup. That is not consistent with the purpose of the BCP program. What they're trying to do here is make up for the fact that they never went after the actual generator of the waste. And
Counsel, I'm going to suggest that you should be mindful of your time.
Okay, let me just read to you what the corrective action under RECRA and the DEC's own regulation says. It says, and this is section, the very long regulation. It is section 375, 376 NYCRR 373-2.6. And subsection L says, corrective action for solid waste management units. This is their RECRA regulations. The owner or operator of a facility which has had or should have had or is seeking a permit for the treatment, storage, or disposal of hazardous waste must institute corrective action as necessary. It doesn't say a subsequent owner. It doesn't say just an owner. It says the person who actually had the permit or sought the permit or applied for the permit. We never did that. That's what that case that we had cited from the third department speaks. It's almost on all fours. It says you can't go after somebody if they didn't ask for or get a permit for a RECRA facility. And we never did.
We'll take a look at that, Counsel.
Thank you, Your Honor.
Thank you. Counsel, proceed.
Good morning, Your Honors. May it please the court, Brian Lusignan with the Office of the Attorney General, representing the Department of Environmental Conservation. The only issue presented in this appeal is whether petitioner was required to seek administrative resolution regarding the department's termination of petitioner's participation in the brownfield cleanup program before commencing this litigation. The answer is clearly yes. Under the statute creating the brownfield cleanup program, the department's regulations implementing that program, and the agreement entered into between the department and petitioner. Nothing in the applicable statutes or regulations, the terms of the agreement, or the department's communications with petitioner excuse petitioner from seeking dispute resolution before going to court. Nor did the department wholly exceed its jurisdiction by conditioning petitioner's continued participation in the program, petitioner providing financial assurance sufficient to ensure that the very source of contamination at the site is eventually addressed. Whether petitioner can be required.
Counselor, can I interrupt you? You don't disagree with the petitioner here that the only request by the DEC was to make the financial assurances. There was no other remedial request on the part of the DEC that caused this dispute between the parties, correct?
The financial assurance requirement is what created this dispute. But the financial assurance.
But his argument is that the requirement to put money up is not asking us to take any remedial action. And if we're not disputing about what remedy we have to undertake, what action we have to undertake on the site, we're not in the dispute resolution. Can you respond to that?
Of course, Your Honor. There's a couple of responses to that, and I'll focus on the terms of the agreement. I do think the regulations make very clear that any dispute arising under one of these agreements is subject to dispute resolution, and that those regulations can control regardless of the terms of the contract. But the contract here is wholly consistent. It says that dispute resolution is required for, quote, decisions on remedial activities, end quote. There's a common sense way to think about this, and then there's a more technical way to think about this. The Supreme Court took the common sense way, which is to say, if you need money to make sure that the source of contamination at a site is eventually remediated, that's, quote, part and parcel, end quote, of the remedial activities. There's a more technical approach which goes through some of the statutes and regulations here. Remedial activities itself is not defined, but under ECL 27-1405 sub 5, remedial program is defined broadly to include, quote, all activities or actions undertaken to eliminate, remove, abate, treat, control, manage, or monitor contamination at or emanating from a brownfield site, end quote. And it includes, specifically by regulation, post-remedial site management, which itself includes engineering controls necessary to ensure the long-term effectiveness of a remedial program. And those engineering controls are also defined to include a financial assurance requirement. So, and that's under ECL 27-1415 sub 7V, or I guess that's in Roman numeral 5. So whether you're talking about the kind of common sense understanding of remedial activities or the way the department and the legislature have defined remedial program, it kind of gets you to the same place, that having money available to make sure that the source of contamination is addressed and we're not just kicking the can down the road for a subsequent landowner to deal with is part of the remedial activities required by the brownfield cleanup program. With respect to this October 2016 letter, the agreement itself provides that informal communications from the department cannot modify its terms. That's paragraph 14F1 on page 122 of the record. In any case, that October 2016 letter was talking kind of big picture about the fact that this site remains subject to corrective action requirements under RCRA, and that the department expects petitioner to eventually address those issues. And the department has been very clear about this on numerous occasions, including in late 2015. And because the department had made that clear in late 2015, that's why department staff said, your time to seek dispute resolution on this issue has now expired. As petitioner acknowledges in his brief at pages 7 and 8, the October 2016 letter says nothing about the financial assurance requirement that petitioner wants to challenge here as the basis of this dispute. There's some question about exactly when this issue came to a head. The regulations require dispute within 15 days of when the party, quote, knew or should have known of the facts which are the basis of this dispute, end quote. That's 375 1.5 of Title 6 of the New York Code. I think the December 2021 letter, which disapproved one of their proposed work plans, is the clearest place the department made that clear, and the first place the department really made that explicitly clear. It includes a list of elements of the proposed remedy, which you can see on pages 177 to 179. Those elements include, quote, removal or treatment, end quote, of the source of contamination, as well as financial assurance for, quote, all remedial activities for the site that have not been implemented, end quote. But even if there's an argument that petitioner wasn't aware at that time that the department was going to require this, they surely were aware by the time the department issued its decision document later in 2022. They didn't seek dispute resolution then, and then surely by the time the department actually terminated this agreement, they didn't seek dispute resolution after that termination. So, regardless of what point in time.
Counselor, when the department sends out its determination, does it put in the notice determination of their right to appeal?
I'd have to look at the notice determination here. I believe that the way this occurred is that the department said that unless you agree to provide this financial assurance, we're going to terminate your agreement, and then they never responded, and that was the end of it. The department's position has been that their time expired in December of 2021, but nothing would prevent them from seeking dispute resolution anyway and proposing and preserving that issue for
Right, we
additional
understand nothing prevents them, but are they notified that they have this window to seek dispute resolution?
Yes, the December 2021 letter laid out 3 options for them. They said you can accept this financial assurance modification. You can terminate your participation in this program, which is a purely voluntary program that offers significant tax incentives and liability limitations for agreeing to complete remediation. And the third option was dispute resolution within 15 days.
Okay, thank you.
Anything further, counsel?
Nothing from me unless your honors have any questions. I thank you for your time.
Thank you. Thank you, counsel.
Thank you.
Case 666, DeMarco Constructors LLC versus Top Capital of New York Rockport LLC.
Good morning, Your Honors. Richard Bell. I am appearing on behalf of the respondent plaintiff here, DeMarco. We had a 3-day, with all due respect to the appellant, we had a 3-day bench trial on this matter, and they're not seeking to challenge any of those discrete findings during that trial. Instead, they're seeking to set everything aside based on an argument that they never even asserted below. This in para delicto. It was never uttered during trial. It wasn't even referenced in their post-trial brief. They referenced the distinctive unclean hands argument, which would only involve DeMarco. Now, of course, they pivoted and are trying to throw one of their own business partners under the bus and said, well, he committed some misconduct. Therefore, we have 2 parties at misconduct, and therefore the whole matter should be set aside. That not only was that not argued, it was not proven below. There was no misconduct. There was no credible evidence of any misconduct by Mr. Giordino representing the defendant. He did what he claims, and really without dispute, that they met weekly with his business partners, that he shared everything with them, including the actual cost, including that it's frank discussions over the upgrades to the facility. There's certainly no allegations of any misconduct by DeMarco. All they did was do exactly what their customer asked them to do in terms of the billing. The only misconduct, in fact, at trial was by the 2 defendants that were found liable for diverting trust funds. So there really is no grounds to disturb the decision below.
Anything further, counsel?
No.
Thank you. Case 67, Koesch versus New York State Division of Human Rights.
Morning, Your Honors. May it please the court. I'm Amy Lefevre-Koch of Osborne Redenberg for the University of Rochester. I understand that this is on submission by the appellant. We do believe firmly that the administrative law judge made the correct decision on this matter. It is fully supported by the record before him at the time. This is an individual who was not accessing services, but instead was a driver. He was texted by the institution when the patient was ready for pickup. When he arrived, the receptionist had left for moments and had returned later. He was able to pick up the patient without any delay. He was expected. So under these circumstances, we certainly do not believe that there was any denial of rights under New York State Human Rights Division.
Thank you, counsel.
Okay. Is there any questions, Your Honor?
I don't believe so.
All right. Thank you very much.
Case 68, Keys versus Nichols.
Good morning, Your Honors. May it please the
Counsel,
court.
if you wait 1 second for your opponent to get settled. No problem. Very good. Counsel, I apologize if I mispronounced your client's first or last name.
I believe you got it correct.
Proceed.
Your Honors, we're here in this premises liability case to ask the court to reinstate the complaint for 2 reasons. The first is factually based, and that's been briefed. And so I won't take up any more of the court's time on the factual basis. The other is legal. The court made a determination that the defect that caused the appellant's injury was open and obvious and dismissed the complaint therefore. Under well-established Fourth Department law, for instance, the Palovi Tri-Main development case or Steenworth versus United Refining Company, the rule has been articulated. An open and obvious condition merely negates the duty to warn and not the duty to keep the premises safe. Now, should the court believe that the finding below that the defect was open and obvious meets the clear and undisputed evidence requirement of Tagle versus Jacob, then I ask that the court should still reinstate the complaint, modify the decision to dismiss only so much of the complaint alleges a failure to warn. If the court has any questions, I'd be happy to answer them. Otherwise, I won't take up any more of your time.
No questions.
Good morning, Your Honors. May it please the court, Tiffany D'Angelo for the respondent. Your Honors, the respondent respectfully submits that the lower trial court made the correct decision dismissing the complaint in its entirety. When you take the factual circumstances of this case together with the legal standards, it was a very clear case of an open and obvious condition, not necessarily even because of the defect itself, the alleged defect, but because of the plaintiff's familiarity with the home, the landscaping, the furniture that was in the yard. She had testified she'd been to this home, quote, hundreds of times. They were previously in a romantic relationship. She had used that exact same bench that caused her injury at least 25 times, according to her own testimony. That, together with the case law that her awareness negates the duty to warn, is what allowed the lower court to make the decision that it did. And I respectfully would request that Your Honors would uphold that decision.
Thank you, counsel.
Thank you, Your Honors.